I'm gonna pull one out. Alright, so now we will be moving on to some real-life examples of these amendments being used.
Because we have real life examples. And pull it up. It's one of my favorite ones.
Oh, right. Yeah, one of our favorite ones.
Yeah.
So first, starting off, we will have the Tinker versus Des Moines, and this will be representing the First Amendment. So the Tinker versus Des Moines court case occurred in 1969, during the height of the Vietnam War. So several students of the Des Moines school district, in order to protest the Vietnam War, wore black armbands, and they wore that to school, where they were suspended by school officials. And so essentially the parents sued the school district, and it was taken to the Supreme Court. And what ended up happening was that the Supreme Court ruled in favor of the students, because unless what they wore was an interruption to the actual school activities and lessons, it is protected by the First Amendment and the freedom of speech and expression to wear armbands and to protest the Vietnam War. So, yes, this relates to the First Amendment because wearing armbands is indeed a part of the First Amendment, and you are protected by that right.
And with the Second Amendment, it's the New Mexico's 7-day waiting period for a gun purchase. The current event is about the Second Amendment, New Mexico's 7-day waiting period after you buy a firearm. People say this is violating the Second Amendment, which I agree with. This relates to the amendment because it is restricting the right to own a firearm for 7 days. Is what they're getting out of it.
That's unlawful right there.
It's illegal. And I feel like there should not be a waiting period, because if you buy something, it's yours.
No.
I mean, I bought a trombone and they didn't give it to me 2 weeks later.
That's unlawful right there.
It's unlawful.
They need that Amazon 2-day delivery.
Well, it said it was going to be there the next day, and it was not there till next
If I buy Sundrop and it doesn't arrive within the next 2 hours, that is unlawful right there, ladies and gentlemen.
Right. And so they're basically telling you that you can't have the firearm until 7 days period is over.
Oh, by the way, would you like?
Yes. Well, thank you. Reese cups. You got to eat them up. ×2.
All right, now moving on to our Third Amendment, the Engblom versus Carey, a court case which occurred in 1982, was a case initiated by 2 correctional officers in New York State after they were evicted from their staff housing amongst their strike. So in place, National Guardsmen settled in the residences of the evicted correctional officers, and the 2 correctional officers then went on trial and claimed that their Third Amendment rights were indeed violated. So in the end, the court ruled in favor of the correctional officers, and the National Guardsmen were considered soldiers, so they are indeed not allowed under the laws of the Third Amendment. And so, yes, this case relates to the Third Amendment, as the officers were a legal resident of the residence, and the National Guardsmen illegally took over the housing. So, yeah, what do you think about that?
That's not good. That is poopy.
That is poopy.
That is poopy.
That is poopy.
I would have ate the Reese's, but I just got my braces tightened and my rubber bands are not coming off.
Yeah, this is poopy.
Fourth Amendment just recently investigated the U.S. Senator surveillance without consent, which is a big no-no. And the senator did not give consent to the FBI to search for his name. This relates to the Fourth Amendment because it says that protection against unreasonable searches and seizures. In my opinion, this is going against the Fourth Amendment because in the article it did not give consent. The article I read said that he did not give consent to the FBI for the search.
Right.
And I don't think they had a warrant either.
And I think that warrants are very important, because without a warrant, the way that it works is that a warrant is issued to the police, and if you are a police officer, you are only allowed to search what is said within that search warrant. And so without a search warrant, first of all, you can't look in that place or the place that you're trying to do a search warrant upon, and you are not limited to what you can search for, and that is not good because the FBI could have gone through lots of personal data, and that is not good because you do not want your personal data out there. That's why this video is sponsored by NordVPN. Our Fifth Amendment case here is from 2022. This was a civil investigation done by New York's Attorney General, Letitia J. This case occurred in 2022 with President Donald Trump, who pleaded the Fifth Amendment to prevent himself from getting self-incriminalized, and this event relates to the amendments as it is the right used in criminal proceedings to protect yourself from self-incrimination and double jeopardy. So, essentially, you are protecting yourself from potentially criminalizing yourself, and just to not say anything that could be used against you. What do you think about this, Zach?
It's good. I like it.
I think the amendment is very good at keeping yourself from getting your things that you say used against you.
Is this the 6th or 7th? Remember? Is it
I
the
think
6th or 7th?
I think it's
Okay, 6.
Yeah.
This amendment's main idea is to have a speedy trial and also have a public trial. One example of this amendment was being tested a couple months back ago, so very recent. So I want to pull it up, and it was back in March in Kennebec County Superior Council in Maine. They failed to provide legal counseling to the defendants in court. So this relates to the Sixth Amendment because they did not give the defendants lawyers to defend themselves in court. In my opinion, they should give them lawyers,
Literally.
because that's literally illegal.
It's literally illegal, and they should not be allowing that.
Right.
Yeah, I think that the right for a speedy trial is very necessary because I think justice needs to be served right away. Ain't that right, Zach?
Yes.
Dang tootin'.
Dang toot.
All right, now we are moving on to the Seventh Amendment. So I believe we were on the 6th, but now we're on the 7th one.
I don't know, 6th or 7th.
So-
Who knows at this point?
There's like 6 or 7 species of bugs biting my leg right now. So now we're moving on to SEC versus Jarkessi. The SEC.
I drink these things up.
Oh, you drink these things up?
Yeah, brother.
Oh, yeah, bro. Drop there.
Throw up.
Yeah. That was very underwhelming.
Yeah.
How it went off. We picked these up. Yeah. All right.
That's your turn.
Well, now we're on the 7th Amendment, the SEC versus Jarkessi case, which occurred in 2024. This was a lawsuit where the Securities and Exchange Commission, or the SEC, sued George Jarkessi for allegedly defrauding investors. So, the lawsuit was taken to the SEC's administrative law judge, which is the administrative Roblox just to
Roblox.
impress.
Yeah, he's on Roblox just to impress.
Ugh, I drank that. This is like our 6th or 7th sun drop of the day. The lawsuit was taken to the SEC's administrative law judge, which is the internal law court. But Jarkessi argued that it threatened his 7th Amendment right because the lawsuit must be taking place in a federal court and not in in-house administrative proceedings, because the jury can be biased towards making Jarkessi guilty. And so the Supreme Court did side with Jarkessi's favor, and the case relates to the 7th Amendment as it guarantees the right to a fair jury in court proceedings and cases. Would you like to add anything to that?
I think that's perfectly good.